We're live.
Hi, everyone. Welcome to our special town hall webinar. We're going to give everyone a few minutes to log in, so please just bear with us. Lynn, are we ready?
Hi, can you guys hear me?
Sure,
Yes,
we'll go ahead. Judge Kroll, we're live.
Okay.
Yes.
All right, Julia, take it away.
Okay. Hi, everyone. My name is Julia Wida. For those who don't know me, I am a family law attorney, and I also serve on the board of directors for the Palm Beach County Bar. The purpose of today's webinar is to find out how COVID-19 is affecting our juvenile and family divisions here in the 15th Judicial Circuit. This program is free and CLE credit will be provided. Please have a pen and paper. I'm going to give you all that information at the end of the program. We are pleased to have with us our administrative judges, Judge Kathleen Kroll from Juvenile and Judge Jessica Tickton from the Family Division. We also have with us today Helen Torres from the Clerk's Office. She's going to be answering some questions as well. If during the program you want to ask questions, please feel free to use the chat feature, and we're going to do our best to take all of your questions in the next 60 minutes or so. So let's begin. Judge Kroll, we're going to start with you. Can you hear us okay?
I can, and I apologize for not being on the screen there. My laptop was in tech office for all day yesterday, and apparently it's not fixed.
No problem. So our first question for you is, how are you handling juvenile matters and UFC cases during this time of COVID-19?
So I am proud to say that the juvenile judges are doing everything possible, all kinds of hearings, adoptions, dependency and delinquency hearings to the fullest, injunctions, everything we can, unless the lawyers object and we can find no remote way to satisfy any rights that need to be addressed. So I was actually looking at our snapshot. We keep a snapshot of sort of what we do, and I compared March 2019 to March 2020, and I'd say we're about 2/3. Our numbers are about 2/3 across the board about what we did last year for the same month. So that means the number of delinquency cases being processed, the dependency hearings, the adoptions, are the number of crossover youth, all those kinds of shelter hearings, dependency hearings are about 2/3 of what they were last year. So we're pretty much doing everything, and that means UFC included. In fact, the last live hearing, full live hearing I had was a crossover UFC hearing.
Okay, if we have hearings before you, can we choose how we and our client get to appear for that hearing? For example, in person, by phone, by Zoom?
Unlike the family division, because we have some constitutional requirements similar to criminal in our cases on the dependency side, you all can't always choose. Some of you might recall the court system was using WebEx for a while before it could get Zoom. We used conference calls immediately when we couldn't even have WebEx yet. So I would say Judge Tickton might have a slightly different answer to that. For us, you really have to use Zoom if you're coming in to us. Okay. And that's because we're paying for it, unlike in family where the lawyers might be paying for it.
Okay, we are going to shift now to Judge Tickton. So I wanted to let all the registrants know that Judge Tickton helped me prepare a chart, which we have provided to you. I believe that Lynn emailed it to you all earlier this morning. So the chart I basically prepared by using the updated divisional instructions that relate to COVID-19 for all of the juvenile and family judges and magistrates. I provided it to Judge Tickton, who circulated it amongst all of the judges and the magistrates, so that they could update that information. What you have now is the most updated version of the divisional instructions related to COVID-19 for the family and juvenile judges and magistrates. Please remember that this is going to be changing as we all go through this experience together. I am going to provide it to the Unified Family Practice Committee. I have already talked to Rob and Cher about this, and I believe they might consider putting it on their website. So I wanted to thank Judge Tickton for doing that.
Well, thank you also for doing that. I did very little, but you organized everything wonderfully. I appreciate it.
Okay. And our first question for Judge Tickton is, how is the pandemic affecting existing time-sharing orders?
Okay, in most cases, it's not affecting the time sharing, and I'm happy to say that. And I want to thank all of you diligent attorneys, because I know that's probably got something to do with how you're advising your clients and communicating with them. You're probably advising them that unless there's something extreme going on, just in general, the fact that there's a pandemic should not just change the time sharing. It shouldn't mean that the other parent doesn't get to see the child, or that you stop transporting the child, or all of those things. And I do want to credit the attorneys for that, because I know that your clients have probably been calling saying, now, we're not in school, it's not summer, how are we going to do this? I don't know how you got it to work, but we've had very few, relatively, I'll say that, relatively few motions coming in. It does seem like a lot when they all come in at the same time. But for those, we do set those quickly. Most of them are not technically emergencies, but you've probably seen the administrative order where we said, if it's a COVID issue, we're setting it quickly. So 5 days, we try to get it heard just so that we can answer those questions, and it doesn't prevent one parent or the other from their time sharing for too long if it's supposed to go forward. Because in most cases, really the time sharing is just going to stay the same. So it would have to be something extreme to disrupt that. So I hope that answers that. We are still expecting people to go to mediation, even though it's a quick hearing. I know you've got 5 days. Mediate it first. If you've got a severe issue and you think that time sharing is going to be affected, mediations are all going by remote mediation now. And there's lots of time available. So there's no reason you can't mediate first.
And I did have an issue where I had to file a motion on behalf of a father who was denied time sharing because of COVID. And it was in front of Judge Suskauer. He did set it within the 5 days of my motion being filed. He also awarded makeup time sharing and fees. He took it very seriously. And I know that we all appreciate the judges taking this stuff so seriously and moving the cases so quickly. My next question for you has to do with the Supreme Court Administrative Order AOSC 2023, the most recent one issued May 4th, 2020. In which they're emphasizing more strongly that all of these non-essential hearings, which are most of the family law matters, should be heard remotely. Do you think that all family law hearings and trials can properly be heard remotely?
Yes and no. It's very difficult. I think all of you are probably experiencing the same Zoom fatigue that we are. So it's possible, it's just very, very difficult, and some cases are more difficult than others. So the answer is it really depends, but we do our best, especially for the issues that really need to be heard. Sometimes I've been in the middle of a hearing on Zoom, and I just have this feeling that there's no way this is going to be upheld, because there's just too much going on, and we're probably going to have this hearing or trial again in person anyway. But if it's something that's really that important that the attorneys and the parties really just need some answer and some direction right now, I think it's better to do it that way in some cases. In other cases, there have been several that both sides have agreed that it's just not worth it and there's nothing urgent about it. So they would rather reset the trial for a date after the whole remote issue. So once everybody can come back in person, they want their trial in person. And I've been happy to grant that. And I think all of the judges, I just met with them by Zoom a couple days ago, and we're all on the same page. So if the attorneys on both sides agree that this is something that just can't be done remotely, then we're all happy to continue it and have you come in person when you can. So, but there are a lot of things that I know we've had trials, we've had evidentiary hearings. The only thing that we have in person is the domestic violence.
So related to this, Joel has a question. And the question is this: as a family law attorney, I have already had non-evidentiary and evidentiary hearings using Zoom. I also had a full trial with one of our magistrates using Zoom. We had no glitches. However, one family court judge sua sponte canceled the trial in May. The grapevine says that this particular judge does not want to do any trials until they can be in person again. The judge has refused to even provide a new trial date. The particular case involves custody and time sharing for 2 children. The case was continued twice already due to no fault of my client. It needs to be heard. What can be done to ensure that all family law judges and magistrates are on the same page in conducting trials?
Okay, well, you're talking about the dream, which is to have, oh wow, Judge Kroll, I see you. We got that fixed, okay. Sorry, the dream is to have consistency with all your judges, and likewise, I know the judges would love for all of the attorneys to be consistent as well, and I don't know if that will ever realistically happen. So I don't know that you can ever guarantee or assure that the judges will all be on the same page. And these issues are really going to have to be handled by each judge on a case-by-case basis. So each judge is familiar with his or her cases, I hope. And depending on what kind of case it is, that judge might determine that there just is no practical way to do it by Zoom. And I don't know which case that is other than custody, what you're dealing with there, but if there are many witnesses and many exhibits and highly technical information, it's possible that the judge knows that case well enough and knows that there is just no way I'm going to be able to make a fair decision or understand the evidence, and it's not worth it to proceed at that time. But I'm guessing, I don't know which judge that is and which case that is, so I really can't answer on a specific case. But just to tell you in general, I think all of our judges are doing, as far as I know, and they're doing the best they can to try to hear what can be heard without causing more problems for families in their cases. And sometimes that does mean continuing it.
Are the judges having regular meetings to talk about all of this and to talk about advancing the cases and actually trying them? How often is that happening?
Every couple weeks, and unless there's every time there's a new administrative order, we have another meeting, we go over everything. We communicate regularly by email, even if we're not having Zoom meetings. But, you know, one of the benefits of having everybody have a Zoom account and, you know, work is a little bit more the hours are a little more flexible because we don't have all these hearings in person. So we're able to, on short notice, get on a Zoom call and get almost everybody participating. And, you know, even if it's over a lunch hour, because I still have docket that I have to work around, but we're able to get together a lot easier now instead of having to drive to the main courthouse or somewhere else. And, you know,
Okay, we're going to move over now to Helen. Helen, I have a question about certified copies. So how can attorneys go about getting certified copies of final judgments or pleadings or orders without having to actually go to the clerk's office now?
Right, so an attorney can get copies of any document on a case by emailing orweb@mypalmbeachclerk.com. So orweb is ORWEB at mypalmbeachclerk.com. And then they will receive a response telling them how much the certified copies would be. They could mail in their payment and receive that copy.
Related to this, how can we now get child support ledgers without actually having to go down to the clerk's office?
And the same, they can actually email us. It's called a clerk web from our website, mypalmbeachclerk.com. There is a link to provide, to email the clerks, and that would be directed to our child support department. They would give us the case number and the ledger, and my team would respond and provide them with a copy of the ledger.
Okay. We're going to shift back to Judge Kroll. So if we have a remote hearing or trial in front of you, how do you prefer that we introduce evidence?
So I think the website that the Supreme Court put out, and I know Robin's sent it out to all of the family judges. She's done excellent, I think, for
Yeah.
the juvenile judges. Actually, very grateful to Judge Titkin. You can see the juvenile guys have no answers on the chart other than Magistrate Prince, who sort of functions more like a family judge in that her subject matters are more like that. But we are designing our own sort of how to do the evidence. We're worried about the subpoenas that go out for witnesses to make sure that the subpoena itself indicates you might have an option to appear remotely. So we are working, the juvenile judges meet weekly at noon on Thursdays, and we're trying to get a uniform division. So it won't be, you got to look up each one of us, how to subpoena under these conditions, how to object if you're a lay person and you get a subpoena. So we're going to produce that and we'll share it with the family bar for sure. So our meeting is Thursday at noon, so something should be coming out quickly. So, but the quick answer to your question about evidence now is we are requiring that a packet of evidence be attached to an email and numbered and sent to all the attorneys involved in that case. The originals be sent to the clerk's office through us, and they have the number, so everybody has the same packet. We are having the same difficulty Judge Titkin mentioned about complex cases where we might be talking about visitation changes where psychiatrists or the lawyers disagree. And we have postponed the more complex cases because we, quite frankly, don't know how to deal with the evidence. We obviously are trying to train on sharing on the screen the documents.
Mm-hmm.
But we have concerns about that because you have to have the physical document go into evidence. So it's a work in progress, but we hope to have a uniform policy by next week.
And Judge Titkin, what's your preference for admitting evidence, introducing evidence?
Right now, it's a similar process. I have asked the attorneys in advance of the hearing or trial to email, exchange all potential exhibits with each other and pre-mark them all, everything, and then email it to me as well. My assistant prints it all out, so I don't review anything in advance. It's a lot of work. So I do have some good positive news that I think, I don't know how soon it's going to happen, but I know our IT department has been working very hard on coming up with an evidence portal, digital evidence portal that will carry forward not just through this pandemic, but well into the future when I'm sure we're going to have a lot more of these remote hearings, at least sometime we will, not everyone. But what I'm hoping we can have is a process where the attorneys will upload all of your documents, all your potential exhibits before a trial. Hopefully every courtroom will be equipped with a large screen so that everybody can see what's on there. And you'll all have use, you all do have use of the computers in our courtroom right now. So you'd be able to have, it's basically a portal that you'd be able to access whether you're in your office or in the courtroom or anywhere else. And you can see all of your exhibits that you have uploaded in preparation for the trial. And when it's the appropriate time to offer any of your exhibits, you would do that from your computer with a little click. It would then show up on the judge's screen, and the judge could click, yes, it's admitted, or no, it is not admitted, and any other details that need to be affixed. Everything else would be automatic as far as what the exhibit number is, the date, which party offered it, whether it's over objection or not, the judge would have to indicate that. And then everything that's in evidence would be viewable by everybody during the trial. And then hopefully once the trial concludes, it would be the judge who sends that, pushes another little button and sends it off to the clerk to do what needs to be done, prepare it for the appellate court and whatnot. So that's my dream, and hopefully we're working towards that. But for right now, we're going to try to get a rough version of that within the next couple weeks, which is not exactly a portal, but I'm looking at this email that I got from our IT department saying that within the next 2 to 3 weeks is their target. They're developing this. So what you would be doing would be attaching your exhibits in OLS, in the calendaring system, so that it would be there. So then we'd still be able to access it all through that. So that's going to be a little bit of a bridge for now. So look ahead for that to come out. I don't know, it's very difficult. None of us have the answers as far as how long is this remote business going to last, and how long till you can come in and do things in person again. I don't know, but you know, it's going to help if we can have a system for evidence. It will make things a lot easier. So if this, God forbid, if this ever happens again, or if we ever need to, or if people just would prefer to do hearings remotely by Zoom in the future, we'd be able to accommodate that.
So that sounds great. A lot of the attorneys have shared with me that they have concerns about how the record is being kept. And I do want to ask you guys, both Judge Kroll and Judge Tickton, questions about what is happening in your courtrooms, and if you know of any of the other judges. And by way of example, so you understand some of the concern that some of the family lawyers have, right after the schools closed down and we started doing these remote hearings, I had 2 Zoom evidentiary hearings almost back to back. And one of them, the judge asked me to physically courier the exhibits that I planned to introduce at the hearing. I did that, and I felt very comfortable. We were able to see him. He would stamp each exhibit as it made it into evidence. I felt comfortable that he had a record there that he was going to use, that was properly admitted, and that's how he was going to issue his rulings and write his order. However, I had an experience just after that where the judge asked me to send a zip folder of all of the exhibits that I planned to introduce. And this zip folder was provided to the judge, to the other attorney, as well as all the witnesses that day. And so we went through this zip folder, and the judge was in his home and had his personal printer. And what I noticed is, as we went through the zip folder, some of the exhibits were objected to and didn't make it into evidence, but I could not see the judge doing anything. So I asked, I said, you know, Your Honor, how can we be sure that the record that you're keeping there, that you're going to use to prepare your order and issue your rulings, is actually the correct set of exhibits that we're looking at in our zip folder that you're saying is coming into evidence? And he basically told me that as each exhibit made it into evidence, he was printing it on his personal printer and then keeping that stack there. And I will tell you, it just made me very uneasy. And at the end of the hearing, I was not given an option, nor was the other attorney given an option to look at any type of list of what actually was admitted into evidence according to him and what he was using for his order. So it was just a very concerning experience.
Well, that's exactly why I was saying that sometimes these judges, we look at a case and we say, this is just going to be too complicated, too complex, not too complicated legally, but just to be able to get everything and know that we're getting the right documents into evidence when we're doing this remotely. So, you know, I mean, we don't have much experience having trials remotely and dealing with evidence. And that's why I think we're all learning together and trying to do what we can to make it work. But a lot of your judges, when you see these complicated trials with a lot of difficult evidence, and if you're going to have a judge printing out thousands of pages for a trial, there's a good chance that trial is going to come back again. You're going to see it again. You're going to get to do it in person. And as much as we hate doing that, that's why if we're sure that this is just ripe for error, I mean, you're basically asking a judge to be your paralegal, to organize your exhibits for you and make sure that the exhibit that you thought you were putting in evidence is the one that went into evidence or opposing counsel's evidence. So, I mean, I just think it's a difficult situation, and a lot of us are doing it the best way that we know how. Like I said, for me, I don't know if my way is the right way or any better than the way that judge handled it. I think it helps us a lot when we have the attorneys communicate with each other and get on the same page. So that's best advice is when you do a trial remotely, is communicate with your opposing counsel, see what you want to do, see how you two, or if there are other attorneys, how you all want to handle it, and get a stipulation. So if you can, on how everything is going to be handled, maybe you can all present one binder, have it couriered to the judge like that, and just do it as one exhibit in a binder. But the more you can stipulate to, as far as evidentiary issues, the better, and the less likely that you're going to have to do the trial again in person.
Judge Kroll?
Yeah, I saw a chat question come through, and it sort of answers one of the concerns I know the juvenile guys are having with, we haven't, juveniles a lot different. Our hearings are shorter generally. So I'm having my first one-day hearing on Monday, and we are having at 4:15, right after this town hall meeting, a pretrial session. And the question that got asked in the chat box there was, you know, are you having pretrials? I think Judge Tick and I are pointing out how much more unlegal work is involved in the Zoom process for the judges and our JAs. You know, making it sure in dependency, we may have 13 participants that have to all be there at the same time, and some of them might not speak English. So, you know, all that management stuff is now taking time. And so the hearing I'm having Monday, we just discussed that we might need more than a day, even though we probably needed less if we were going to do it live. But we are going to go through the evidence together this afternoon. We're going to try to get that all together beforehand. You know, I've offered to copy stuff, and it's got the problems that you articulated, which is, you know, what would I copy? Is it the right thing? And I just made a note, make sure before I put it in that they all, both lawyers, or there's 4 lawyers involved, they all see it because you've.
Yes.
So I think it's a work in progress, and that's what, you know, we're all trying, and I think there's added burdens to the judicial side of it that are risky. And that's what we're sort of saying. We're trying to figure out how to make sure they're not risky.
Okay, Helen, we have
Yes.
more questions for you. So what is happening now with Courthouse Mediation?
So courthouse mediation is run by court administration. It's not a function of the clerk, but my understanding is that they are doing mediations via Zoom. And when I reached out to them, they told me that you can schedule them through OLS and they will be Zoom mediations.
Is there any reduction in hours or reduction in staff, or is everything the same?
My understanding is that they're fully staffed as far as their hours go. I think that you'd need to call the main mediation number and find out what their hours are. I'm not familiar.
And how can parties pay mediation fees online now?
So parties can pay mediation fees through the e-portals. Attorneys can pay the mediation fees for their clients. There is an option for a mediation fee, whether it be the $120 or the $60, depending on the income. And there is a form that they would upload, a notice of paying mediation fees that they would upload in the e-portal in order to pay the fees.
Okay. Judge Kroll, we come back to you. So in the Supreme Court Administrative Order AOSC 2023, do you have any concerns about the requirements that in-person visitation pursuant to court orders under Chapter 39 be suspended?
Actually, you're gonna have to ask that again, but before you do, But when you started, I was just thinking, we're expecting any minute. You guys know that, a change. I'm sure you know, you can see it online. There's a COVID committee,
Yep.
fancy name for it. And the rep from the juvenile side is the judge in Broward, Judge Hope Bristol. Some of you may know her. And she's been in touch with a judge in the Panhandle and myself a lot to sort of talk. And I can tell you right now, they're even considering some rule changes in juvenile under the 8, Section 8, which is us. They just handed me 5 pages of rule changes. So I assume they're doing that. I don't know who's the judge on the family side for that committee, but I assume they're doing the same thing in family. So,
So basically, in the Supreme Court administrative order, they've taken the in-person visitation that happens sometimes in Chapter 39 cases, and they've suspended it. And they're basically saying that they prefer that it happen via video communication.
right. That's because of the secretary.
Do you think that these parties have the ability to do that for in-person visitation as an alternative? And then also there's a part of that order that basically says you are allowed to ask the judge to reinstate the in-person visitation if you feel like there would not be a risk to health, safety, well-being of the child or the adults who are involved in the in-person visitation. And I wanted to know if you've experienced that yet. Has anyone filed a motion to reinstate it? What are your thoughts?
We get a lot of disagreeing parents in juvenile, and visitation's a big issue. It might not even be a crossover case. I know I just had a meeting with ChildNet, who's doing the virtual visits. And one thing I thought about we should share with family lawyers, if you are going to go virtual because of medical reasons or grandparents in the house or whatever, there are a lot of virtual suggestions by all the psychologists and social workers on how to make those more successful. And so we have a list by age, like if you're dealing with a 1-year-old, 2-year-old, 3-year-old, what kinds of things for the 10, 20, 30 minutes of the virtual can you do to make that a more effective visitation? So a quick answer to your question is, have I had any motions? Yes. We've even had hearings about changing those things. We are under the guidelines of the secretary, and then of course the Supreme Court. So we're limited into what we can do, but yes, definitely there are times it's always difficult to override something where someone could be medically affected or even die. So whether it's, give the kid the ADHD pill, and one parent doesn't want it to happen, or do the operation when the parents object. So yeah, the answer is yes, we've had them, and yes, we do sometimes override them.
Judge Tickton, on social media, there's a lot of discussion about how there's been an increase in domestic violence during this time of COVID-19. Have you noticed that there's an increase in the filings of petitions for injunctions for protection against domestic violence?
I don't know how to answer that because we've changed things dramatically with the whole DV process. So it's hard to measure. I think the clerk could give you a better answer, but for what the judges usually each judge had a different day of the week for domestic violence hearings. And I used to have anywhere from maybe 6 to 12 hearings or domestic violence trials on any given Wednesday. When the pandemic hit us, we changed everything so that the judges would rotate and there would be domestic violence hearings only one day a week. So here in South County, it's every Wednesday, and you're going to have a different judge covering all of the week's domestic violence trials. So if each judge had, 5 trials usually, now each week we have about 15 to 20 just for one judge to cover. So I don't know though, because each judge has a different philosophy on when to, what kind of case qualifies for a temporary injunction or a hearing. Some judges dismiss them a lot easier than others without a hearing. So I don't really know, I'm not aware of what my colleagues, how many they usually have on their docket. I know I usually on a normal day have between, 6 to 10, but now it's 20.
Julia, I can
Yeah.
tell you from our end, from the clerk's perspective, the numbers have maintained their consistency. I haven't seen a sharp increase or a decrease. I do know, sitting on the Domestic Violence Council of Palm Beach County, PBSO did report that they saw an increase in numbers in March and April, in addition to legal aid saying that they've had an increase in individuals that they're representing.
Okay. So Judge Tickton, I'm going to stay with you for this question. The Supreme Court administrative order, there's reference to the family law forms and the requirement that the forms not be notarized or signed in the presence of a deputy clerk if the filer includes the following statement before their signature. Under the penalties of perjury, I declare that I have read this document and the facts in it are true. Do you think that this is going to hold up if someone tries to attack it?
I don't think I can answer that. That's a great question, but I think it's really just gonna depend on the situation, and I can't comment on that because it's something I might be ruling on if it comes before me, but it would certainly depend on the facts involved.
Okay. And Helen, I have some questions for you too. Are you seeing anything at the clerk's office after a judge has a Zoom hearing, whether it's a hearing or a trial? Are you receiving anything afterwards in terms of what was admitted into evidence? Any type of list of the things that were used in the preparation of an order that came from that Zoom hearing or that Zoom trial?
So we do receive the evidence after after the juvenile and the family hearings. We receive evidence. It's received by our evidence clerk. She doesn't particularly get any indication that the hearings particularly been held by Zoom. I do know for a fact that we have received evidence from Zoom hearings, but whether it's a Zoom hearing or an in-person hearing, we do an evidence log of the evidence we receive, and that evidence log is then sent over to the evidence department with the evidence. So I say that to say, if an attorney had a question, they could reach out to the evidence department of the clerk's office to review the evidence and the log to see what was entered into evidence.
Okay. Judge Tickton, you mentioned earlier in the webinar that you're still requiring parties to mediate before you're setting hearings. Are you still requiring mediations before any temporary relief hearing is set?
Yes. Yes, they should mediate as much as you can to try to resolve it, because you have a better chance of doing that, especially if you know that you're going to be limited to a remote hearing or doing it, through Zoom, and it's going to be a lot more difficult and challenging for the court to figure out what's really going on. So I think the parties definitely should continue mediating, and a lot of mediators are accommodating by mediating through Zoom or other technology. Yes. So it's easier than ever. Like I said earlier, there's really no excuse for missing a mediation. I think it's going to continue into the future as well if the rules allow for the virtual mediation, so that people can get these done quickly and efficiently, especially when you're waiting for a hearing date. It's a lot easier to schedule those Zoom mediations. So yes, please.
For Judge Tickton and Judge Kroll, for the hearings or trials that were continued or canceled because of the situation, are they going to be given priority in terms of resetting them?
I know it's going to be a different answer for the juvenile cases because you have very specific time limits that you have to do things. I can tell you for family, the consensus is that we are going to have to decide on a case-by-case basis. There's no blanket answer we can give you because it just depends. So if there was a trial that got knocked off my calendar last month and it's a typical run-of-the-mill divorce case, and I have a trial coming up next month that's been set and it's a relocation case, I'm not going to knock the relocation case for a divorce trial that is okay waiting. So it really just depends. If there are cases that need to be expedited that were knocked off, of course, I think all the judges are going to give them priority and might need to bump some other trials out of the way to get that taken care of, but it's all just going to have to work through. And if you think that you have a trial that was taken off the calendar that has some reason that it should have priority, that's something you're probably going to have to raise with the judge, bring it to the court's attention, and ask that it be treated with priority status.
I know the committee, I know the juvenile judges had to submit suggested criteria to prioritize cases. I don't know if the family guides did too. I don't know if they're trying to do some kind of statewide considerations to put perhaps in some order to us. But definitely in the family area, the age of the child, the length of time the kid is permanency, those kinds of things are definitely going to impact the movement of those cases. And of course, termination of parental rights trials have been on total. We just have done none of those.
I know in family, we're hoping that if it's a post-judgment case, if it's a modification, that you will utilize the magistrates. That will help us keep our trials that are already set. So even if you had an objection to the magistrate and you were set before the judge, consider talking to your opposing counsel and saying, listen, if you withdraw the objection to the magistrate, let's just get it set so that we don't have to wait another 6 months or so, and we'll catch up. If we have enough cases where both sides are willing to do that, we will be able to catch up and get back on top of it. But the priority is going to go to the original cases. That's what the judges said, and the family judges said in our last meeting, was they're going to be giving priority to the original divorce cases. So if you've got a case where they've already had their chance, already had their fun divorce trial, and they just can't stay away, they want to come back for more fun, then they're just going to have to wait a little longer or go to see a magistrate.
Okay. So Helen, have there been any changes to how people can pay child support?
Well, there haven't been any changes, but there are ways that people can pay child support without having to come into our office. They can pay the SDU directly, and that address can be found on our website. And they can also pay online on www.myfloridacounty.com, and they can pay online with My Expert Pay. Excuse me, it's expertpay.com. They can sign up as a registered user and they can make their child support payments online versus coming into our office and waiting on them.
And Helen, is there anything else you want to share with our registrants about anything that's changed at the clerk's office since COVID-19?
Well, we were closed for a time, but we've been back open and doing all of our services as of this past Monday, May 11th. So for us, we are practically back to normal.
Okay. So this question is for both Judge Kroll and Judge Tickton. And it's kind of a long question. Do you have anything you would like to share with the family law attorneys who are concerned about these remote hearings for children's issues and such personal, important matters, including concerns about the record, the shortened amount of time we have because of the technological issues, the restrictions on presenting our case to the fullest, and the inability to adequately prepare our clients and the technological limits on their testimony for hearings and trials that really matter for them and their children?
I think I've already addressed this overall, but again, I think it's helpful to discuss with your opposing counsel, the procedures that you can agree upon, stipulate whenever possible. And if it's going to be something where there are going to be a lot of objections and concerns, and we're still going to go forward with the trial by Zoom, then I think it's probably a good idea to request that you have a pretrial conference with your judge so that you can go through some of those things and not take away time from the trial. Obviously, it's difficult because a lot of the rulings, evidentiary rulings, we can't make until we're there at the trial. So do what you can to try to narrow those issues and stipulate when you can. Be reasonable. I know it's asking a lot, but the more reasonable, the more you can work together with your opposing counsel with those difficult trials, the easier it's going to be for everybody. And we're doing our best to get through it. So I I was hoping to get some ideas from the attorneys, and if they've seen other things work for, you know, other judges and other courts, share that with us. Let us know, because we're doing our best, and we're really entering a whole new world here. We're all pretty lost and just dealing with it the best we can. Nobody means to cause any problems. It's very frustrating, and I'm sure you've all been part of some Zoom hearings or trials where you just want to scream because there's issue after issue, whether it's starting up on time and trying to get everybody into the room and then not having people connect and people can't hear, or the sound comes out with like a robot voice and it's choppy, and you know, it's very difficult. I think from all of the judges' perspectives that I'm aware of, we all feel like we're working twice as hard to get the same thing done, and we're not happy about it. We don't like having to be restricted. We much prefer to have the in-person trials and have our busy days back in the courtroom with everybody coming in and going business as usual, but we're just doing the best we can. So we're open to your ideas and suggestions so that we can get this easier and do it the right way.
I guess from the juvenile division sort of has had sort of three, I'd say, main concerns. One, the record itself. We've discovered that, you know, obviously under the rules, the record has to be the official record has to be not the Zoom record that's being recorded, but the one that comes from the courthouse. And it's difficult at times to hear, with different people's ability to connect, their Wi-Fi connections, their phones, their audio, if it's with the video or not. So yeah, we definitely have issues about the record itself. We had a lot of problems with interpretation, whether, you know, the interpreter was standing live with us in the courtroom, or they were on Zoom, or they were on the phone and the person was on Zoom, all of that technology. And I guess that goes to the second concern the juvenile judges have raised, which is no one knows how long this will last, and are we preparing our courtrooms for that next phase? You know, you'll hear the feds talking about plexiglass and you know, all sorts of things, and you know, big screens. We don't have them in juvenile.
We don't have them either. We just want it.
Yeah, we're not the civil world. So with the big bucks, so you know, we're looking at that. Are we preparing ourselves for issues that we are going to have in the courtrooms themselves? And the third issue, record, second, the courtroom preparation, and the third would be really the people, the witnesses. You know, it's different when you're the litigant or you're the lawyer. We deal with kids, and some kids in dependency are a party. And who makes the decision how they should appear, if they should appear, and are we subjecting them to risks that we shouldn't? And that leads to that hybrid type, and I guess you probably have that in family too, where suddenly one lawyer says, I have a pre-existing condition, or I have a parent at home, or I have small children and I can't come. You know, so this is going to be on Zoom or remote in some way. And eventually with distancing, the other might be in the courtroom. And how do you make sure that record's okay? And that all know what everybody else is seeing. I'm often in my courtroom looking at my laptop, and maybe the state attorney is home, but a public defender on a plea has shown up. Or it's the case worker who's on the screen as a witness, and the parent is in the room, and they can't see what I see. So all that stuff has to be worked out. So we have great concerns.
Okay, well, I want to thank the panelists for being with us today. Thank you, Judge Tickton. Thank you, Judge Kroll. Thank you, Helen. We really appreciate your time during this very challenging period. Thank you so much. To the registrar, you need some information to post your CLE credit. So the title of the course is How COVID-19 is Affecting Our Family and Juvenile Divisions. The course number is 2002632N as in Nancy. Again, 2002632. N as in Nancy. Thank you everyone for joining us. Please stay healthy. The Palm Beach Bar is here if you need us. Have a wonderful weekend.
Thank you, Julia.
Thank
Thank
you.
you so much.